authorized dealers of Gibson and Epiphone guitars. Come visit us at 65 Clayton Crux Street, Heritage Square, Cape Town, or 92 Edward Street, Tiger Valley, Belleville, and let our friendly and knowledgeable staff help you find what you need.
ding rukkie.
Good afternoon to all of you, and thank you very much for tuning in. It's Wednesday afternoon, the 17th of May, and it's Labour Talks with me, Commissioner Samuels from the CCMA. Good afternoon, welcome with me and Mr. Juan, who is behind the technical desk this afternoon. We trust that you had a great weekend and a great week so far, and we trust that this afternoon's discussion will be just as fruitful, engaging as usual. Thank you very much for tuning in. I would like to encourage you that please share the link to as many as you can on your social media platforms. So for all of those that cannot come to the CCMA, they don't have time to phone for inquiry about matters that is important to them in terms of employment, relationship. This is the platform that has been created. Thank you very much to the management of Radio Eerste River, a group of amazing young people that is running this radio station out here in Eerste River. Radio Eerste River. Ons stasie, ons talent en ons mense. So I would love for you to tune in, share the link as far as you can with as many as you can, and we want to encourage you to send in any voice notes, any WhatsApp inquiries that you have. Please send it to us via voice notes. You can also send us an email at ccma@radioeersteriver.co.za. I also want to tell that you can also send your inquiries through also to the CCMA directly, ctn@ccma.org.za. You can also phone. I'm not stopping you or preventing you to go into our offices and speak to one of our officials in the office about a matter that you feel you need a personal conversation. So you're more than welcome also to come to our offices. CCMA office in Cape Town are 78 Darling Street in Cape Town, just opposite the castle. It's in Darling Street, opposite the castle. You'll find the CCMA. It's called the CCMA House, and you will first meet the security staff that will then direct you to the third floor or the second floor once it's our renovations has been completed. Then you will see and speak to one of the officials there if you want to have a personal discussion. Other than that, if you feel that you have a query, you just want to bounce off with us and you feel it's not so complicated, you just need some guidance, some direction, where to go, what to do with your matter, please drop us an email, drop us a WhatsApp message. We will try as best to give you answers at this platform without you moving a single space. You can do it in the comfort of your house. If you have data, airtime, Wi-Fi, drop us a message and please share this. We received a couple of inquiries, and I thought that maybe to start off the program this week, we've dealt with last week with unfair labor practices. We've zoomed into the difference between the suspension and what is a layoff, and we dealt with a court case that distinguished between the two, that even as commissioners we cannot put things into the act or into law and create categories of natures of dispute. If there isn't a category for a particular nature of dispute, it just means that the CCMA do not have the jurisdiction to deal with the matter. It doesn't automatically mean you don't have a complaint. It just means that the CCMA would lack the jurisdiction to deal with your matter, and then there is another forum which you probably have to go to. It would most probably be either the High Court, Magistrates Court, or directly to the Labour Court, especially in light if you have a particular complaint and the LRA or even the BCAA, there is no category defined where your nature of complaint literally falls under, and then you would have to go somewhere else. Again, let's deal with the queries that came to our desk. So thank you very much to our regular people that is tuning in with us on social media. Thank you very much for the comments as well that is being posted. Thank you for the positive messages that we received. But one very interesting one, I know Pastor Dr. Rian Yunus out in Swellendam, they are all out listening. I know people in Worcester, Pastor James Davids and the Ebenezer Congregation Restoration Family Church out in Worcester, they all listening and tuning into Facebook and watching us on all these social media platforms. Thank you very much for all of your support and for sharing the link to as many as what you can. But Samantha Miller, a very interesting query that she sent us through in the week. En sy sê, "Hi, ek wil net weet, kan jou werkgewer die werknemers in 'n polis sit wat die werk self betaal. Die polis van die company gee dit vir ons as iets met ons oorkom. Dan is daar ook geld vir ons families, maar toe ons sien vir 3 jaar kry ons niks tax returns nie. Toe sê hy ons eers, sy's jammer, van hulle het ons verkeerd ge-explain, want ons betaal die polis van die company het, en ek dink hulle gebruik die taxgelde. Volgens die inquiry, lyk dit asof die werkgewer die tax return gelde gebruik om hierdie polisse te betaal. Nou die eerste vraag is dat dit is 'n polis, dis 'n probleem by die werknemers. Kyk, as 'n werkgewer 'n polis betaal namens die werknemers, daar's nie 'n wet wat daarmee hanteer dat hulle dit nie kan doen nie. Dit is amper soos enige familielid van ons wat 'n polis betaal namens ander familielede, en dan wanneer iets oorkom met ons of iets gebeur, dan eis hulle die gelde. Natuurlik kan hulle dit eis, want hulle het dit betaal. Ons het dit nou nie betaal nie, ons families het nie die polis betaal nie, so natuurlik sal hulle in staat kan wees om dit te kan eis. So die vraag nou is dat kan die werkgewer dit doen namens my? Die antwoord sal natuurlik ja wees. Kan die werkgewer die geld aftrek van my? En dit is waar die probleem is. Indien die polis betaal word van jou tax return, dan dink ek jy moet definitief by SARS uitkom en net by SARS vra, is dit reg dat my werkgewer ons tax return gelde gebruik om dit te betaal? Want sover my kennis strek, is dat jou tax return is wat jy invul elke jaar, en dat die geld word in jou rekening inbetaal en nie soseer 'n werkgewer nie. As dit is dat die werkgewer die geld kry in sy rekening van jou tax return, dan is daar ergens 'n fout. Daar's 'n probleem ergens, want ek dink nie SARS betaal daai gelde in enige ander persoon se rekening behalwe ons eie rekeninge nie. So Juffrou Mille, ek sal maar net voorstel, kontak SARS. Die tweede ander opsie is ook natuurlik om die ombudsman ook navraag te gaan doen by die ombudsman wat polisse hanteer, om te hoor, is dit wat die werkgewer doen reg of het is verkeerd? Ek is seker die ombudsman sal ook vir u in die regte rigting plaas, want ek lees ook volgens hierdie navraag dat u was ook by die Unie, en het lyk asof die Unie ook nie vir hierdie antwoorde gegee het nie. So ek sal aanbeveel, ons maak nie die deur toe nie, ons sê net, waartoe u kan gaan nou? Gaan na die ombudsman, en ek is seker die ombudsman sal vir u die regte inligting gee rakende die polis. Kan iemand anders die polis betaal en dan die gelde eis, want dit gebeur op plase veral, wanneer die werkgewer 'n eenmalige polis betaal vir al sy werkers, en dan as iets oorkom, dan eis die werkgewer hy geld, hy benefit, hy kry die geld, gaan hoor maar by die ombudsman, is dit ethically reg? Kan dit gebeur? En wat kan gebeur as jy dit graag wil stop? As ons nie wil hê dit moet gebeur nie, dan kan ons natuurlik navraag doen om dit te laat stop. Mr. Glenn Paulson, thank you very much for tuning in with us, and thank you for your support all the way out there in Wetton and Newlands, upgraded house in Newlands. So thank you very much for your support as well. As I said, Juan is with me, and we're going to take a music break right now. Thank you.
Dreamed I went to heaven, you were there with me. We walked upon the streets of gold, beside the crystal sea. We heard the angels singing, and someone called your name. We turned and saw this young man, and he was smiling as he came. And he said, friend, you may not know me now. And then he said, but wait, you used to teach my Sunday school when I was only 8. And every week you would say a prayer before the class would start. And one day when you said that prayer, I asked Jesus in my heart. Thank you for giving another man stood before you and said, remember the time a missionary came to your church, his pictures made you cry. You didn't have much money, but you gave it anyway. Jesus took the gift you gave, and that's why I'm here today. Thank you for giving to the Lord. I am a life that was changed. Thank you for giving to the Lord. I am so glad you gave. One by one they came, far as the eye could see. Each life somehow touched by your generosity. Little things that you had done, sacrifices made, I noticed on the earth, in heaven now proclaim. And I know up in heaven you're not supposed to cry, but I am almost sure there were tears in your eyes as Jesus took your hand and you stood before the Lord. He said, my child, look around you, for great is your reward. Thank you for giving to the Lord. That was changed. Thank you for giving to the Lord.
Feeling a little under the weather? Come down to Casmade Pharmacy and let our family provide your family with all the essentials as the flu season reaches its peak. Fight those flu symptoms with our range of over-the-counter meds for all types of coughs and sore throats. Boost your immune system with our wide range of immune boosters such as Activo, Flugon, and Linctagon. Casmade is here for everyone. Our staff will assist you with all your health needs. Our contact number 021-745-6252. We are located in 192 Blue Downs Way, Tuscany Glen in East River. Casmade is a family providing for your family.
Welcome back. Thank you and good afternoon to all of you. Today's program, we're going to talk about representation at the CCMA. Very interesting topic. It just happened so that we gave some training this morning to a corporate company, and I realized that why don't we take this topic to the radio station as well? Because the big question from many people that comes to the CCMA is, can my brother, can my mother, can my sister, can they come with me to the CCMA? Can they come and represent me? Because number one, I'm not that talkative, and number two, I'm not that strong when it comes to some labor law. So we're going to talk about that this afternoon, but another couple of queries that I just want to deal with. Pastor Dr. Rian Jonas out there in Stellenbosch, one of the union officials that work out in Swellendam, and he brought a couple of queries to me, and I thought that, well, let us bring it to this platform, because I'm sure that there are many other people that have the similar or same challenges at the moment. The big question is, can my employer or must my employer pay me out my years of service, my diensjaar? Moet die werkgewer my diensjare uitbetaal indien hulle my afgedank het? Kom ons sê dit weer vir die rekord. Section 41 of the BCA says says that if my employer dismiss me for reasons based on operational requirements, then the employer must then pay me out 1 week for every completed year. So it's only under the circumstances when you are retrenched, basically, that your employer has to pay you out for all the years of service. Now that's where a lot of people throw money away, because they work 10 years, 15 years, 25 years at a company, they resign, then they expect that the employer must now pay them out a certain money for the years of service. I would recall that even one part of the law, we need to talk about that thing, because a person can even work for a company for years, and then when they retire, that is where the law also draw a line. You don't qualify for your years of services when you even retire. Isn't that just unfair? So please, on the WhatsApp line, send me a voice note, send me a WhatsApp message. What is your thoughts? That means when it's only circumstances when I'm retrenched, it's beyond the control of the employer, beyond my control, that I'm now being retrenched. It's only under those circumstances that my employer, by law, have to pay me 1 week for every completed year. That is the minimum. 1 week. I've seen employers that give far more than that. The Lord just says that is the minimum I must get. I've seen an employer that are willing to give 3 weeks even for every completed year, 2 weeks for every completed year. But the minimum that I should get by law is at least 1 week for every completed year of services, is what they call a severance pay then. Once you get your severance pay, the employer then applies for a tax directive, and then your money gets paid out. And for inquiries on your tax and the amount of tax you pay, I'm sure there's a tax table from SARS that will assist you. You can approach SARS, and I'm sure they will help you what your tax implication would be on your severance pay. The second question that Pastor Dr. Rian Yunus mentioned, which is, I think it's very important, and we've touched on this many times, but I will just reiterate. It's when an employee are asked to sign documents, any document by the employer, if you are illiterate, and you feel that the employer just pushes documents in front of you to sign, please make sure that you get either somebody that understand what you sign, but do not, let me encourage you, do not sign any document unless you are sure what you are signing for. Because later on you may just find yourself that you have signed for a resignation, because some employers are very clever out there. Very, very clever. Some employers, they will let people sign documents, especially when they know that you are illiterate. Now, the law says that if you do have to sign or look at any document, whether it's a contract of employer, the employer must make sure that you understand what you sign for. Understand the documents that is in front of you. You cannot claim that you are forced to sign a document after hearing what I'm encouraging you now to do, not to sign, and you sign a document and then claim that you are forced to sign. And that is what we get at the CCMA. A lot of employees, when they come and the employer says, but Commissioner, this case should not be at the CCMA, because why? The employee have resigned and there's the document. Once the employer pulls out these documents to say we have resigned, the first thing the employee objects to is to say, well, I didn't know what I was signing for, or I was forced to sign the document. And that is where people get into trouble, because once you've signed a document, it doesn't automatically mean you are going to lose your case. It doesn't automatically mean you don't have a case. It just makes it difficult for you to have leverages in your matter if you cannot prove. Because remember, the first hurdle that we have to get over is to prove to the commissioner that I was forced to sign the document. Number one. Number two, that I was ignorant to sign a document, that I was unaware. Maybe the document was underneath another document and they let me sign the one, thinking that I'm signing for my pension money, or thinking that I'm signing a settlement agreement, and then just to be told that I have signed my resignation. So be careful. can I encourage you, be careful what you sign out there. If an employer puts any documents in front of you, it's your right to refuse to sign. It's your right until you get clarity. If you understand what you sign for, whether it's a resignation, whether it's a settlement agreement between you and your employer, then you will take responsibility of your actions. It's clear. But if you are unaware what you're going to sign for, then it's your right to lodge a complaint. You bring the matter to the CCMA. In the case where an employer now says, well, I've got you, you signed your resignation, you can now claim either constructive dismissal by the CCMA because there's a resignation. You may not be able to prove now that the conditions were that intolerable, but if you can prove that you were forced to sign the document, it may put just leverages on your matter. The commissioner will have to weigh all these things up, because the first rulings that the commissioner has to make is, number one, were you forced to sign the document? Did you sign the document under duress? Now, many people, and this is where we have controversial thinking as well, that if an employer says, and they love to do this with employees, if you don't sign the document, then you're not going to get paid either tomorrow or the end of the week. Now, we can look at that, and please share what is your thoughts on this, because I would definitely put, when I am being forced to sign a document in relation to me getting money, would that not amount to duress? Because surely that would be a forceful way of getting me to sign a document. It's like a carrot in front of me. If I don't sign, I don't get money. Now, if I refuse to sign and I lodge a complaint, then my fear is, how do I survive financially? Let me say this. If you have worked and provided your services, you don't have to sign an agreement, a resignation, to get what is legally yours. Remember when we signed contracts of employment, we said to our employer, I shall provide my service, you shall remunerate me for my service. Now, if the employer is withholding, you're not withholding your service, you've provided your service, but the employer is withholding the remuneration. You don't need to sign any document for your money to be released. Your money is legally yours. If this employer refused to give you what is legally, statutory yours, then you come to the CCMA. You go either online, you lodge a complaint. It would fall under the category of what we call Section 73A of the BCA. It's that kind of complaint, because it's a complaint for outstanding monies arising out of the BCA for services that you've rendered. You don't need to beg for your money. It's legally yours. So be careful what you sign, because this employee was unaware that he was signing a document, and lo and behold, the employer then told him afterwards that he signed a resignation. Now, yes, we can claim we were unaware. Yes, we can claim that I was forced. You can still bring your matter to the CCMA if you feel aggrieved. Only if you feel aggrieved and you feel you need to take the matter further, that you will then come and approach the CCMA so that we can assist you in setting your matter down, in having a hearing, because the employer now needs to come and explain to the commissioner, why did they let you be forced to sign a document where you are now claimed you were forced. So it's good. Approach the CCMA. That is why this institution exists, is for people who feel aggrieved in the manner that they have been dealt with at the company. If you feel unfair labor practice, you feel you've been unfairly treated, discriminated against, then that is the time when you will now approach the CCMA. Okay, so before we go into the most serious matter of today, I just want to make you aware again and reiterate, there is a national bargaining council for the private security sector. Effective, they've been opened since the 2nd of May. They are in Cape Town, Golden Acre. Please, if you work in the security sector, do not approach the CCMA unless it's discrimination matters. Do not come to the CCMA. I'm guiding you now to avoid you spending time, money, efforts at the CCMA, which you don't have. You don't have all the time. You don't have the money to travel up and down. So I'm guiding you. If you have a complaint and you work in the private security sector, please go to the bargaining council. It's good news because that bargaining council has been set up to deal with all the disputes arising out of those employment relationships. So I'm going to ask Mr. Juan to entertain you. And after this break, we're going to dig into the most serious of topics for the day as who can represent me at the CCMA. Thank you. Stay tuned. Please share the link. Don't go anywhere. Okay, Mr. Juan, are we okay?
Just waiting in our old familiar place, an empty spot beside him where once I used to wait, to be filled with strength and wisdom for the battles of the day. I would have passed him by again, but I clearly heard him say, I miss my time with you, those moments together. I need to be with you each day, and it hurts me when you say you're too busy trying to serve me. But how can you serve me when your spirit's empty? There's a longing in my heart, wanting more than just a part of you. It's true. I miss my time with you. To offer, how can I truly care? My efforts have no meaning when your presence isn't there. But you'll provide the power if I take time to pray. I'll stay right here beside you, and you'll never have to say, I miss my time with you, those moments together. I need to be with you each day, and it hurts me when you say you're too busy trying to serve me. But how can you serve me if your spirit's empty? There's a longing in my heart, wanting more than just a part of you. It's true. I miss my time with you. I miss my time with you. Those moments together, I need to be with you each day. And it hurts me when you say you're too busy trying to serve me. But how can you serve me when your spirit's empty? There's a longing in my heart, wanting more than just a part of you. It's true. I miss my time with you. It's true. I miss my time with you.
Westervier.
Our station, our talent, our people.
Die ding rukkie.
Thank you very much. Welcome. Welcome back. Matthew Clark, thank you very much for tuning in with us, and thank you very much for your support. Please share the link to as many as we can on all the social media platforms. And today we are talking about who can represent me at the CCMA. Now in April 2023, the CCMA have issued new rules that came out. And now as commissioners, we are yet to go through some of the training sessions and unfold and unpack the new rules. But I thought that Rule 25, which deals with representation at the CCMA, it's important for listeners, for viewers, for everybody out there to understand who can represent me at the CCMA, who can come into those hearings and support and present my case at the CCMA. So I thought that maybe today we will discuss that, and in light of all these things that is happening around us with regards to the unfair dismissals, unfair labor practices, these disputes that come to the CCMA, let me say this to all of you, that you don't need to have the legal background. You don't need to be a lawyer or a specialist in labor law to approach the CCMA. You don't need to have all these human resources, diploma and certificates and psychologist degrees to approach the CCMA or to present your matter. We have seen over the years people who had little qualification, blue-collar workers, win their matters at the CCMA. People with little background of labor law have won their matters at the CCMA. I think one of the cases that we will deal with in one of the programs, and I hope that we do it very quickly, very soon, and not after today, that we will deal with the matter of Sedumo versus the Platinum Mines, which clearly indicates that the ordinary security person can tackle one of the biggest organizations in South Africa to the highest court, which is the Constitutional Court, and win his case. That's what that matter proves to us. So you don't need to have legal background in order, number one, to get to the CCMA and to have a winning case. All you have to have is your story. If you present your story in the most credible way, reliable information that you supply, in the most probable version that needs to be approved or to be acknowledged, then you have a very strong matter in winning your case. Because at arbitration, which is the very legalistic process at the CCMA, it is without a legalistic process. That is where you will have your evidence presented, you'll have your witnesses that you will bring along with you, and it's arbitration that one party wins and one party loses. I want to encourage you, please, if you have experiences with the CCMA before, you've been to our offices, you've been in some hearings, and you want to share some of your experiences with the rest of us, please share with us. Send us a WhatsApp, a voice note, send us an email, send us your comments as well, what your experiences were, and to help others understand what they need to do when they come to the CCMA. Now, Rule 25 is the rule. Now, like any organization, the CCMA have rules, and Rule 25 talks about representation at the CCMA. Now, when it talks about representation at the CCMA, this is what Rule 25 looks like in terms of the law. This is, let me read it. We're going to go through it slowly but surely, and I'm not going to rush it. We were just joined by Mr. Jayo behind the technical desk. So Mr. Jayo has just joined us. Representation before the commission. Now, Rule 25 says, in conciliation proceedings, a party to the dispute may appear in person or be represented only by, listen to this very careful, if the party is an employer, a director, or an employee of that party, and in addition, now you see that it says director or employee. Now some people have it that when a manager comes and present their cases at the CCMA on behalf of the employer, that employees feel, but why is the manager here? Why is the owner not here? Because it's the owner that fired me. There it clearly states that any person who who is an employee of the company designated by the employer to represent them can represent them at the CCMA. We as commissioners, we check, we verify the credentials up front. Who is present with us. We check the parties. That is the first thing we do in the processes, is that we verify who should be there, who can be there, and if there are any objections of any party who should not have been there, then we deal with those things up front of what we talk about representation. But it clearly says a director or employee. The person could be even the cleaner at the company. Can the cleaner even represent an employee? The cleaner is an employee. The cleaner can represent the employer. The tea lady can represent if they are employees of that party. And in addition, if it is a close corporation, a member or employee of that close corporation. Number 2, any member of that party's registered trade union. Now that's the key word, registered trade union, because a lot of people go to advice offices. There's nothing wrong. Let me say this. There's nothing wrong if you want to go to an advice office and go ask for advice on labor law. We don't exclude you not to go. We can't prevent you, because Section 23 of the Constitution talks about everybody's got the right to fair labor practice. Everybody. So it's your right to go to whomever you feel you want to go to get legal labor law advice. If you want to go to an advice office, it's your right to go. But in terms of this Rule 25, you can clearly see advice officers are not part of that group of people that have the automatic right to represent a party in the proceedings at the CCMA. It says a member of the parties registered. That's key. Not just any trade union. It has to be a registered trade union. So how do you know that the organization that you go to is a registered trade union? You can go on the website of the Department of Employment and Labor, because the registrar who sits part of the bargaining unit of the Department of Employment and Labor sits in Pretoria. They issue a list, 2 lists. One is registered trade unions, who they are, which ones has been deregistered, won't appear on that list anymore. It's only the unions that appear on that list are regarded now as registered. Then they issue the other list, which is a list of registered employers organizations, so that you can check, so that if an employer takes you through a disciplinary hearing and there's an employers organization who is chairing the hearing, taking control of the procedures and the processes, it's your right to question the validity of the documents, the authenticity of the person sitting opposite you as the chairperson. It's your right as an employee to ask also for documentations to verify whether the person who is sitting in front of you as the chairperson is exactly who they say they are, that there is no misrepresentation, there's no fraudulent representation. So the key word is registered. So registered trade union, or registered employers organization, or an office bearer or official as defined in the Act, or an office bearer or official as defined in the Act of a registered federation of trade unions or registered federation of employers organizations. Number 3, if the party is a registered trade union, any member of that trade union or any office bearer or an official as defined in the Act and authorized to represent the party. So there's a couple of documents that we as commissioners look at. Number 1, we would ask for credentials if we feel that if we see that it's the first time that a party appears in front of us. Now, for the sake of information sharing, sometimes if you are at the CCMA and you see that the commissioner don't ask for the credentials of a particular party, it might be that the commissioner have seen that party before in a process, and he has already verified the authenticity of the credentials of that person, and he sometimes won't ask for it again. That could be one of the reasons why a commissioner won't ask for the credentials. When you see that happening, it could only be that. But it's your right to ask also. If you feel that you're not going to get a fair outcome because you feel a bit tense that the commissioner and the other party know each other. They laugh at each other, they smile, they make little jokes amongst each other before the start of your hearing. It's your right to question that kind of relationship so that the commissioner can make it clear to you in what capacity the other party is there and why the credentials has not been verified at that specific point. But the first thing, if a commissioner sees any party that is a representative party for the very first time, the first thing the commissioner will ask them is to present their documents, to verify and to authenticate also. So it's our role to make sure that everybody gets a fair hearing and they are fairly represented. So, number 4, if a party is a registered employers organization, now you'll find a lot of employers making use of employers organizations. Now, in our view, in simple language, we will now say, this is the company's lawyer coming, but they might belong to an employer's organization. Our role, it's our right to ask for the credentials. You don't have to just take it by face value when you see the chairperson in your disciplinary hearing or you see them at the CCMA, coming to the CCMA. It's your right to ask the commissioner to verify the authenticity of the other person sitting there, especially the employers' organization. Because just as unions are required to be registered, employers' organizations must also register with the Department of Employment and Labor. They have to register. So it's important to understand that so that when you sit in the proceedings at the CCMA, then it is clear that when the other person sits on the other side, you are confident that the credentials has been verified. Because once you know who the other party are, either party of the table, you can now be at ease to present your case. But if you are not sure, your mind will play the whole time on verifying and why the commission is allowing people in a hearing room where you didn't now get the authenticity or the verification process has not been done. You won't present your matter in the manner that you have pre-planned it prior to you coming to the CCMA. So I don't want you to even sit and while presenting your case, your mind flows on the representation on the other party, while when that is made clear, my role as a commissioner is to ensure that before that arbitration hearing starts, that both parties are calm, collective, and in their full mind to present their case. I want you to present your case to the best you can. Whether you will lose it, whether you will win it, I just want you to give the best that you can when you appear at the CCMA. I'm going to ask Mr. J.O. That was now a mouthful said before we continue. So I'm going to ask Mr. J.O. to entertain you with some music, and then we'll continue after the break.
Yes, Rafi.
Our station, our talent, our people.
Tidang Ragi.
Should the shadows come? Why should my heart be lonely and long for heaven's home? When Jesus is my portion, sparrow, and I know He watches me. His eye is on the sparrow, and I know He watches me. I sing because I'm happy. I sing because I'm free. His eye is on the sparrow, and I know He watches me. I sing because I'm happy, and I sing because I'm His eye is on the sparrow, and I know He watches. Yes, I know He watches. I know He watches over
Our station, our talent, our people.
Tidang Ragi.
Welcome back. Thank you very much, Mr. Patrick Andre. Thank you very much for tuning in. Emily Daniels, thank you. And Yossi L, thank you very much for tuning in, and thank you for the support to this program, Labour Talks, on a Wednesday afternoon between 3 and 5. Please share the link on your social platform to as many as what you can, so that those who cannot come to the CCMA, then they can at least at this platform hear what their basic rights are in terms of disciplinary hearings, what their rights are when they are being treated unfairly in the workplace. What should they do? Because there's so many unhappy employees in the workplace, so many things that make us unhappy and make us disgruntled. As they say, unhappy employees make productions very low. You don't feel like you want to stand up off the bed even to go to work. You feel like you can just grab your bags any given day. So there are situations when employers makes it intolerable for us. So please, if you can, share the link to Angie Hugh out there in Woodlands. Thank you very much for your support, your tuning in as well. And we trust that the information shared at this platform, that it is very reliable, informative, and that you can use this information in your work situation to make it better, for the relationship to be advanced. A query that came through, daar's 'n navraag wat deurgekom het. Meneer Joost sê, ek hoop nie gee om nie. Meneer Joost het vir ons 'n navraag gestuur. Hy sê, hi meneer, ek werk vir 'n company as 'n security. Hy het sy SIRA papiere, hy werk hier in Eerste Rivier. Ek gaan nou, en hy het 'n groot probleem daar waar hy werk. Hy werk by 'n estate, en daar waar hy werk is daar 'n Zimbabwean. En die Zimbabwean het nie 'n SIRA papiere nie, maar hy is aangestel as die hoof van die sekuriteit. En hy het al reeds een persoon al gedismis. En wat ek hier lees op die navraag sê hy ook, as die mense van SIRA, die inspekteure nou daar kom, dan sê die company dat hierdie Zimbabwean, hy is nie 'n security ou nie, maar hy is een van die skoonmakers, ja, hy's een van die skoonmakers, maar elke dag sit hierdie ou in die guardroom, voor die kameras, en hy gee bevele, en hulle soek na hulp. Hy's 'n graad B security officer en die baas weet alles, maar die baas doen niks nie. Nou dit is hierdie tipe navraag, dit is hierdie tipe klagtes wat al een of ander tyd, laat ek dit sê, een of ander tyd moet ons regkom. Een of ander tyd moet dinge daarom regkom, of lyk asof het regkom. Ons kan nie nou nog na 25 jaar hierdie tipe gedrag van 'n werkgewer kry, wat sy werknemers se klagtes ignoreer nie. Een of ander tyd moet dit regkom. At some point things has to come right at our workplaces. Things cannot go wrong all the time. I mean, yes, we've got this amazing constitution and labor laws and Employment Equity Act, Unemployment Insurance Act, Compensation, Occupation, Injury and Diseases Act, Occupational Health and Safety Act, and the Labor Relations Act as well. We've got all these amazing acts, but at some point, these things needs to stop. Okay, meneer Jooste, ek het die oplossing vir u. Daar is 'n bargaining council nou. So u hoef nie na Sira toe te gaan nie. Ek wil hê u het regte word beskerm, meneer Jooste. So ek wil hê dat u moet by die bargaining council uitkom. Ek sien ek het u e-posadres. Wat ek gaan doen, ek gaan vir u sommer die besonderhede van die bargaining council stuur en dan het u dit, hulle telefoonnommer, hulle adres en dan wil ek hê u moet so gou as moontlik by die bargaining council vir die sekuriteit hierdie klag ook gaan aanmeld, want dit is onregverdig en ek dink dit wat hierdie werkgewer doen om 'n Zimbabwean aan te stel en oor julle te wees as 'n toesighouer ook, dit is unfair. En dan as die Sira mense daar kom, dan word daar gesê hy is maar net een van die skoonmakers. Dit is unfair. Nou dit is sulke werkgewers wat ons moet vasvat, wat nie moet wegkom met sulke gedrag wat hulle hiermee besig is nie. So please thank you very much for that inquiry, and I would encourage you, I will send you the details for the security sector. I will send that off to you, and I want to appeal to you to make a complaint, open a case at the bargaining council. So thank you very much. So kom ons gaan verder. In terme van verteenwoordiging by die CCMA, dit is waaroor ons gesels. If a party, now it also says that in conciliation proceedings, a party to the dispute may appear in person or be represented only if a party is the Department of Labor, any employee or official of the Department of Labor. That's Department of Employment and Labor. If we read the new, the name has just slightly changed. They've put employment in, so it's the Department of Employment and Labor. Now, if you look at that, it's very specific to which government department it is. Very specific, because if you have a complaint from any other government departments, there's a bargaining council where you will go to, unless it is unfair discrimination, which you will then bring to the CCMA, because the CCMA is the only statutory body that can deal with unfair discrimination, and your sexual harassment matters will come to the CCMA. The Department of Labor, of Employment and Labor, has been specifically put in here in the clause under the representation. It's because in terms of section 69(5) of the BCEA deals with what we call compliance orders, and the compliance orders are only issued by the Department of Employment and Labor, the labor inspectors. Let me explain. A labor inspector comes out to a company, investigate in terms of, they don't specifically come to see what is wrong in your company. They have a mandate with a form, and there's tick boxes that they must tick off. A couple of boxes, and I'll just run through it. I might not have all the information with me, because one of these days we'll bring one of the experts in to talk about it. But they will tick off boxes, for instance, to say, do you get written particulars of employment? Question 1. And they will tick it off, either yes or no. Do you get a pay slip? Yes or no. Do you get your leave according to the BCA? Yes or no. Do you get sick leave according to the BCA? Yes or no. It's tick boxes. If the labor inspector tick one of those boxes as a no, that means the employer is non-compliant with the BCA, the Employment Equity Act maybe, and even the UI Act, because one of two questions they will deal with in that form. One question will deal with the latest proof of payment for the registration for COIDA, which is Compensation, Occupation Injuries Disease Act, and they will also ask for the latest proof of payment to the Unemployment Insurance Fund. Now, if the employer cannot produce these documents, the Labour Inspector then issues a compliance order. That's what the Labour Inspector does. Once the compliance order has been issued, and the employer, after 21 days, so, as I said, one of these days we'll get one of these experts from the Department of Employment and Labour to talk to us about that process, how they do, what does the inspectors do, and how do they get to the enforcement. But I'm bringing this in under representation because after they issue the compliance order and 21 days has passed, because the compliance order is specifically, it says that the employer has 21 days within which they must comply with those sections of the Act that has been identified as non-compliance. If the employer is still in non-compliance, the 21 days has passed, then the Department of Employment and Labour applies to the CCMA either for that document to be made an arbitration award, or if the employer feels the Labour Inspector was at my company, but the Labour Inspector didn't speak to him, the Labour Inspector was a bit arrogant in his viewpoint and have just issued the compliance order, he may object to the compliance order. So that is why they're bringing it in under representation as the Department of Employment and Labour, because the Department of Employment and Labour becomes either the applicant, or the Department of Employment and Labour can become a respondent in a proceedings at the CCMA. So they have automatic rights in terms of the proceedings at the CCMA. So, in any arbitration proceedings, a party to the dispute may appear in person or be represented only by a legal practitioner or a candidate attorney or an individual entitled to represent the party at conciliation proceedings in terms of the sub-rules. Now, key, number C, if the dispute being arbitrated is referred in terms, now, look this, the compliance order, outstanding money claims of the BCA, or is about the fairness of the dismissal, and the party has alleged that the reason for the dismissal relates to the employee's conduct or the capacity, a party is not entitled to be represented by a legal practitioner or a candidate attorney in the proceedings, unless, so if your dispute is about outstanding monies, you're claiming the money, then what it just says is that a party is not entitled to legal representation unless the commissioner and all the other parties agree to consent to that. And the commissioner concluded that it is unreasonable to expect a party to deal with a dispute without legal representation after considering. Now, there are 4 things. And I've added a 5th one in there, and we'll deal with that now, the legal representation. So what it says that if your complaint is about outstanding money, if there's a complaint against the compliance order, if your complaint is about the fairness of your dismissal, only related to 2 things, your misconduct or the capacity, meaning poor work performance, incapacity, ill health, or the 3rd one in terms of the incapacity, which is comparative abilities at the organization, whether you are a fit for the organization, one of those things, then there is no automatic legal representation. The commissioner must either consent, parties have agreed to that, or you must now apply for legal representation. And these are the 4 things we're going to look at after this break, after Mr. J.O. have just entertained you with some music. So after the break, we will unpack the 4 things, and I've added a 5th one in, which I will just briefly explain to you. But please share your thoughts on the WhatsApp line. Send us a message, any query, send us a voice note so that we can deal with it. Share your experience as well. Thank you.
Yes,
Our station, our talent, our people.
Tidang Ragi.
Just a child when I felt the Savior leading. I was drawn to what I could not understand. And for the cause of Christ, I have spent my days believing that what He'd have me be is who I am. As I've come to see the weaker side of me, I realized His grace is what I'll need. When sin demanded justice for my soul, mercy said no. I'm not gonna let you go. I'm not gonna let you slip away. You don't have to be afraid. Mercy said no. Sin will never take control. Life and death stood face to face. Darkness tried to steal my heart away. Thank you, Jesus. Mercy said no. Oh, yeah. God so loved the world that He sent His Son to save us. From the cross He built a bridge to set us free. Oh, but deep within our hearts there is still a war that rages and makes a sacrifice so hard to see. As midnight fell on crucifixion day, the light of hope seemed oh so far away. As evil tried to stop redemption's flow, mercy said no. I'm not gonna let you go. I'm not gonna let you slip away. You don't have to be afraid. Mercy said no. Sin will never take control. Life and death stood face to face. Darkness tried to steal my heart away. Thank you, Jesus. Mercy said no. And now when heaven looks at me, it's through the blood of Jesus, reminding me of one day long ago. Mercy said no. I'm not gonna let you go. I'm not gonna let you slip away. You don't have to be afraid. Mercy said no. Sin will never take control. Life and death stood face to face. Darkness tried to steal my heart away. Thank you, Jesus. Mercy said no. Oh, yeah. Mercy said no.
Our station, our talent, our people.
Tidang Ragi.
Welcome back. And thank you very much to you are tuned into Radio East River. This is Labour Talks with me on a Wednesday afternoon between 3 and 5, where we unpack some of the most important issues currently trending on the labour law market, in terms of case law, in terms of updated labor relations matters. So this is the platform for you to engage with me on a Wednesday afternoon. Thank you very much to one of my colleagues, Commissioner Orlando Moses out in Silver Sands. Thank you very much for tuning in, and thank you for your comment. I will deal with that now. Mr. Monterey Joseph, thank you very much. Union official that's working in Cape Town alongside Ms. Jean Baker. Thank you very much for tuning in, supporting, for sharing the link to as many. And thank you for being a freedom fighter for the unjust and those little guys that cannot fight for themselves when it comes to big employers that they have to face when they are being unfairly treated out there. So thank you for the support and for the sharing. I just wanted to, for Mr. Uester that have sent us the query through with regards to security sector, it doesn't matter what the nationality is of the person now wanting to take charge over people. It is simple, it's not complicated. The CIRA have certain recommendations and certain requirements that if you operate in the security sector, what that registration process is. If you feel that whoever, doesn't matter what the nationality is, where the person is coming from, but if you feel that the person who has been placed over you as a supervisor, as jy voel dat die persoon oor jou gesit word as 'n toesighouer, dat die persoon is nie, het nie die credentials nie, het nie die regte papiere nie, ek wil u aanbeveel, gaan na CIRA toe ook en lê die klag ook by hulle, sodat hulle weer kan inkom. Vat 'n foto, vat 'n video as dit so moet kom, sodat u kan bewys dat dit wat die werkgewer sê die persoon doen en dit wat u kan bewys wat die persoon is, maar dit is u reg om nie die klag sommer net so te los nie. Veral as u nog steeds gegrief voel oor die aangeleentheid wat nou gebeur. So dit maak nie saak van wat die nationaliteit is wat die persoon is nie. As hulle nie geregistreer is nie, behoort hulle nie te operate as supervisors in die kapasiteit nie. Hulle moet registreer en daar is sekere vereistes wat hulle moet voldoen. Net voordat ons gebruik het, we were dealing with Rule 25. Who can represent me at the CCMA? Now, we're only dealing with representation at the CCMA, but I just want to, for all those small business owners, and if you are working as a union official even at these small business owners, or you feel that you can represent certain people in a certain sector, let me say, if there is any disciplinary action being taken against anybody, the law don't say specifically in what manner we must deal, but sets out a procedure. It sets out some substantive issues, how we need to look at. It talks about representation. Now, normally with your disciplinary code or your procedure, you will stipulate who the people are that will represent employees at that specific workplace. You may even say it could be a union official of the choice or a fellow employee of the choice. If the person who's going to represent the other party in whatever proceedings is going to be helpful to your proceedings, is going to assist you in resolving the matters. Because the last place you want to be, the last place I want you to be is at the CCMA. We don't want you at the CCMA. You don't want to come to the CCMA. If our role in this life is that we are called to be peacemakers, our role is to ensure that if there are some injustice and some inequality and some unfairness, is to bring the two parties together. If the other party cannot see what they do is wrong, then you bring them to the CCMA. That is why we are there then, is for us now to hear both parties, to hear what the unfairnesses are, and to literally make a decision. When two parties cannot make a decision, the commissioner will then have to decide based on what he hears, balances of probability, and then he will then have to make a decision if the two cannot make the decision out of their own, whether they are right or wrong, whether they see. Because I said many times, sometimes we need to see disputes and complaints or an inquiry, not through our own eyes, because through our own eyes, we will see many people as wrong. When constructive dismissal cases happen, do you know how many people sit at the CCMA? And this is what they do. The employer did this, the employer did this, the employer. They point all 10 fingers straight to the employer employer that did such a bad thing to them in the employment relationship. And no finger goes back and say, but what did I do wrong in this employment relationship that resulted that it went so bad? Because I'm sure things didn't go this bad all the time. Somehow, somewhere, something went wrong. Because when you started to work at the company, things must have been good. You had a good relationship. You had a good management relationship with the employer, with the owner of the business. You were interviewed, you got the job, or the job hunted you, or they headhunted you, and you got the job. So the relationship was good at some point. But we need to address this elephant in the room by saying that at some point something went wrong. And it is, you cannot just blame, because they always say the relationship is not just for one person. There's two people involved in the relationships. In every relationship, there's two people that makes that thing work. It's either you and the manager, you and the supervisor, you and a fellow employee, or you and the owner. Could have been any. So we need to look at that. So this is what the commissioner, if the parties now needs to apply for legal representation, they then come to at the arbitration hearing, and then they either do it in writing prior to the start of the proceedings. Some employers, they will either send an application for legal rep in a form of an affidavit, founding affidavit. They will send it through the other party, and they will send it through to the CCMA, and then they want the CCMA commissioner to make a decision. Now, the commissioner can hear the legal representation orally by the two parties in the proceedings, and he either gives the parties a break. Most cases, sometimes the commissioner will give a break, and then he comes back after he has consulted maybe with one of the senior commissioners on the submissions that has been made. He will come back maybe a couple of minutes, and he give a verbal ruling. If he continues with the arbitration, it means then that he has granted the legal representation, and the other parties agree that the matter can proceed. Or even if there was an objection in the beginning, that if he declines the legal representation, that the parties then still feel that they want to continue with the matter in arbitration immediately. In that cases, the commissioner issues the ruling as part of his award. Or the commissioner could take all the submissions on a particular day of both parties, hear the legal representation application on record, puts the recorder on both parties. The other party gets an opportunity to oppose it, or you can just say you don't oppose the matter and it will stand. But the commissioner, even if it's unopposed, the commissioner must still apply his mind whether he will grant it or not grant it. And these are the things that the commissioner will look at. So if ever you are in a situation that you need to apply for legal representation at the proceedings at the CCMA, these are the four things that you will have to put as part of your application. Number one, this is what the commissioner has to consider: the nature of the question of law raised by the dispute. The nature of the questions of law raised by the dispute. What is the nature of questions of law raised by the dispute? If, for instance, your dispute, let me give an example. If your dispute, for instance, is also linked to the POPI Act and your personal protection, it's now linked to another act as well. And there's questions of law that the commissioner will have to deal with when it comes to the whole submission of the arbitration proceedings, even if it has to do with a whistleblower, that you're bringing all those things to the foreground as part of your nature. It becomes a very complex matter to deal with questions of law. So that is what is referred to, the nature of the questions. So in your submission, you will then unpack that for the commissioner. Because remember, you're making an application for legal representation. You want the commissioner to grant you legal representation. And one of the issues to look at is, what are the questions of law that will come out of your dispute? And if there are, surface that in your documentation. Number two, the complexity of the dispute. Now, Sometimes some disputes might not be that complex because every nature of complaint has to either come out of your disciplinary code or it has to come out of the disciplinary procedure, your contract of employment. Because if you are being charged, remember that there's 5 things the commissioner look at in terms of Schedule 8, Item 7. Is there a rule? Now, those rules can be part of your contract of employment. It can also be part of a code of conduct. It can be part of the rules of the company. So, is there a rule? That's number 1. Was the employee aware of that rule? Now, if you are being charged, you have to be charged from an offense that you've committed from rules that you are aware of. And those rules are part of your disciplinary code. So when we talk about the complexity of the nature of the dispute, it should not be that complex if your charge sheet is exactly the contents of the disciplinary code. Meaning, if you were absent without permission and there's a rule that says absent without permission, disciplinary hearing, that's simple. That can't be that complex. If there is a rule that says under the influence of alcohol, it's a rule. Am I aware of that? Yes. Late coming, it's a rule. It's not a complex matter. It's not difficult to understand it because the bottom line, all the commissioner wants for you to tell your story. If you can tell your story, again, in the most credible way, reliable information that you supply, that is more probable of your version to be the truth. I don't see where a commissioner would go wrong in granting an arbitration award in your favor, because your story at the end of the day in the arbitration award is what the commissioner, and part of his analysis will then unpack why, because part of the story is the commissioner must determine which of the stories is the most probable to accept based on the evidence, based on the testimonies, and based on all this, the commissioner has to make a decision. So when we're talking about the complexity in the dispute, you look at the charge sheet. What was the charges that was brought against the person? And if the employer has fabricated charges beyond your disciplinary code, where they now come up that you failed to submit a report that was meant to have been in by the 10th of April, and you now, that it's part of the charges, and they make it more, and in that doing so, you have defrauded the company with R1 million, and it becomes so complex that you yourself don't even understand those charges. Yes, I agree with you. Make it part of your submission of how complex those disputes are, because the employer didn't make it easy by just extracting from the disciplinary code. The employer just populated stuff as they felt the need to bring it in. And mostly, obviously, when you look at those natures of the complaint that, or the charges that's brought against us, it's aimed to let us go. It's aimed to dismiss us. It's aimed to find us guilty already. Before these disciplinary hearings even have started, employers would want to find us guilty on it. But maybe at that second point, I'm asking Mr. Jayo to relieve me a little bit here. Please share your comments, share your experiences, what you've experienced so far in terms of the proceedings at the CCMA. Give us some guidance as well. What is your viewpoint on this matter? Thank you.
Yes,
Our station, our talent, our people.
Tidang Ragi. Rivier.
Our station, our talent, our people.
Die ding rukkie.
Welcome back. Good afternoon to all of you. I trust you had a wonderful day so far on this Wednesday. The third one is that what the Commissioner has to look at. It says that the Commissioner concludes that it is unreasonable to expect a party to deal with a dispute without legal representation after considering public interest. That's the third one. Now, public interest could be that if the dispute has links to what the public would have an interest to. I'll give you an example. I was dealing with a matter out in Hermanus where there was industrial action against this big company out there, and the employees who stays in the community and in the location, they then got involved. There was community meetings about what is happening at the company, and because there was some actions happening with the misconduct during industrial actions also, that the employer took these employees through a protected strike, but there was misconduct and took them through a disciplinary hearing, dismissed about 18 of the employees, but the community was in uproar. So the community had an interest in the outcome of the discipline of the arbitration hearing of these 18 employees. So they needed to apply for legal rep, and part of their submission was that the community, there's a public interest in this matter. And not only that, there's public interest in many other matters. During the COVID-19 pandemic era and the period from 2020 up until, 2022, for that period, remember the CCMA dealt with arbitration hearings as well, where employees were dismissed for refusing to be vaccinated, for instance, all those things. So those issues had a public interest because it directly, whatever the Commissioner decided upon, had a direct interest to the public as well. So if you can show good cause that legal representation is required because there's a public interest in the matter, if the legal rep is not being granted, that it is linked to a public interest, you will have also part of a strong matter. The last point that the LRA or the rules stipulate talks about the comparative ability of the opposing parties or the representatives to deal with the dispute. Let me just say the comparative ability. Beautiful, big word, comparative ability. It's just, how do I measure up to the other person on the other side of the table? That's just it. Om in plain Afrikaans te sê, hoe weeg ek op teenoor die ander persoon aan die ander kant, as het gaan kom by die CCMA? Het ek die nodige skills, kwalifikasie? Van baie kere gaan jy kry dat 'n werkgewer bring die human resources departement manager wat nou 'n psychology degree het ook na die hearings toe, en hulle is meer informed as wat ek informed is. 'n Gewone werker, ek het maar net staan dat 8 uit die skool het, ek is nie so hoog geleer nie. So hoe compare my ability nou met die ander persoon aan die ander kant van die tafel? Comparative ability. So one of the things that the Commissioner has to hear on record is the submissions from both parties. And let me say this, some employees really underestimate themselves and they undervalue themselves in many ways. Why? Because you may be an introvert and may not have been outspoken, but when it comes to fighting your matter as a matter of social justice and freedom fighter, many employees do come out. They are assertive. They are very good in articulating their problems to the Commissioner. And strangely, it is based on their submissions that they can also win argument when it comes to comparative abilities as well. If you can prove that the other party are highly educated, more probable that they will present their matter, whether it is during cross-examination, that you will be under pressure or placed under pressure when there's cross-examination, and that person will maybe just interrogate you in such a way that you will feel that you are being victimized and bullied through the process. Let me give you the guidance. It's the Commissioner's role to ensure that nobody gets bullied or victimized throughout the process. It's our role to ensure you, as the employee, when you feel that the other party is even probing questions with you that is irrelevant to the matter, it's your role to object to any processes of questions that the other party is doing towards you. Now, comparative ability. Does your qualifications measure up to the employer or the other party's qualification? Does your ability to present your matter, does it equal up to the other party when they present the matter? It's your right also to object to these things when it comes to the proceedings at the CCMA. So those are the 4 things. May I add, apart from the comparative ability, if I could add this, and please share me your comments, but this is just from my side. I think that one of the things that we also need to look at is the prejudice. Maybe, I don't know. Tell me what is your thoughts. Prejudice would just mean, what is the harm the other party will suffer if legal representation would be granted? Say the commissioner decides to grant the legal representation application to whichever party has applied now. What is the prejudice that the other party will suffer? What is the harm that you will suffer? And maybe, I don't know, I'm just putting it in there. There's 4 things by the rules submitted in Rule 25. Maybe we can add another one. Maybe we just add prejudice. What is the harm that I will suffer if they suddenly allow the lawyers and the attorneys to make their presentations in the arbitration proceedings when it comes to dismissals for misconduct, for instance, and the employer. Another part of representation, which is very interesting from the rules, it says, in any facilitation, we had this question a couple of weeks ago in the office, can a legal representative represent an employer when it comes to large-scale retrenchments? Here's the answer. In any facilitation of large-scale retrenchment. Now let me stand still. What is large-scale retrenchment? Large-scale retrenchment is if you intend to retrench 10 people and more, and you employ 50 people and more, then and that is what is deemed to be. That is the criteria to be used to be defined in terms of a large-scale retrenchment. Now, 50 people and more, 10 people and more being retrenched. So that's your criteria for a large scale. So in any facilitation such as that, as contemplated in terms of Section 189A of the Act, a party may appear in person or be represented by, keywords, a director, employee of the party, and if a close corporation, a member or employee of that close corporation. Any member, office bearer, official of that party's registered trade union, or any member, office bearer, or official of that party's registered union or registered employers organization. Very interesting. It actually specifically says, very interesting, it says, no representation by legal practitioner or candidate attorney shall be allowed in facilitations of large-scale retrenchments as contemplated in Section 189A. Very interesting. It just says it, no representation. So we don't need to argue. We don't need to debate about it. It says, F also, no person representing a party in proceedings before the Commission in a capacity contemplated by 1A or B, other than a legal practitioner or candidate attorney contemplated, may charge a fee or receive financial benefit in consideration of agreeing to represent that party. Wow. So you cannot charge a fee if you are going to agree to represent a party. Very interesting. 2, if the party to the dispute objects to the representation of another party to the dispute, or the commissioner suspects that the representative of a party does not qualify in terms of this rule, the commissioner must determine the issue. So the commissioner has to hear. Our role is to hear the submissions. We cannot just outrightly come out and issue a ruling directive right in front and say, sorry, sir, you're not allowed. We have to go through the submissions. We have to hear. We have to be on the record so that if there is any actions done by a commissioner that could be construed as reviewable. Remember when we talk about the levels, you get to the CCMA, if you're unhappy with the proceedings of the CCMA, unhappy with the outcome of the CCMA, unhappy with any conduct of a commissioner that has resulted in a negative outcome to your case at the CCMA, and then in terms of the LRA, you can take it to the Labour Court for a review. That's where your next step would be, take it to the Labour Court. If you are not happy, and there are still employees that come back to the CCMA after the Labour Court have now issued a judgment against them, they approach the CCMA. Let me guide you here. Let me say this to all of you. If you can hear me, share this wording, share the link right now. If you are not happy with the outcome of the Labour Court, do not come back to the CCMA. Approach the Labour Appeal Court, because you now need to take the matter to the next level. You then go to the Labour Appeal Court. You go back to the Labour Court and ask them what is the next step. Where do you go to? So that you don't waste time, energy, and money that we don't have to spend. Okay, on that note, I'm going to ask Mr. Jayo to give us a music break right there. Thank you. Thanks for tuning in, and thank you for staying with me. Any comments, any feedback, drop us a note on the WhatsApp line, voice note on the WhatsApp line, the WhatsApp message. Send us an email, ccma@radioeasterriver.co.za. Please send us any messages, any inquiries. We will try our best at this level, at this platform. Thank you to Radio Easter River, the management of Radio Easter River, allowing us to be here. So please share with us, and we will address it at this level. Thank you very much.
Our station, our talent, our people.
Tidang Ragi.
Was there when you drew the breath of life, and I could hear your voice the first time that you cried, and though you couldn't see me, I was very near, and there's something that I want you to hear. You will always be a child in my eyes, and when you need some love, my arms are open wide, and even when you're growing old, I hope you realize you will always be a child in my eyes. And I was there the first time that you prayed, and I heard all the promises you made, and when you fell before me, crying, Father, I have sinned, I picked you up and held you close again. Be a child in my eyes, and when you need some love, my arms are open wide, and even when you're growing old, I hope you realize child in my eyes. You will always be a child in my eyes.
Yes, Rafi.
Our station, our talent, our people.
Tidang Raki.
Well, welcome back, and thank you very much for tuning in. And thank you for the comments as well, and thank you for the positive energy, the positive questions and feedback. Yes, we are sometimes have to be motivated working in unmotivated circumstances when employers just make it so difficult for us with whether they don't want to give us an increase, and even if they do give us increases, then they give us increases that could be so insultative to our intellectual capacity. There's some employers out there that you won't believe it, that is at the moment offering even 1% increase as an annual increase. And how laughable could that be? So employers, instead of, because we contribute a lot to the profitability of organizations, and when they come back with a ridiculous offer of an increase of 1%, it is laughable to some employees, and it could create hostile environment by suggesting such an increase, because it could be seen as a huge insult to employees when they get these ridiculous increases that employers want to give. But we are amazingly grateful to amazing people out there, and one of them is Mr. Monterey Joseph. Amazing people that work very tirelessly in the labor market for the injustices against individuals who cannot fight for themselves. So, Mr. Monterey Joseph, thank you for the question. What are the key factors that anyone should know in terms of preparing for an arbitration at CCMA, especially if they don't have representation from an employee's perspective? Thank you for that, Mr. Joseph. And maybe we're going to run ahead of what I wanted to do, but it's maybe also a good thing that if we deal with it now, it can link up to our program for next week. Arbitration proceedings, how to prepare for your arbitration proceedings. So we can start off this week, and if I look at the time that we still have for the show for today, we will only have a couple of minutes to deal with these things, and we will definitely link up with it by next week as well. So it's a continuation next week of this week's program in terms of how to prepare for your arbitration. Very good, because you can be, number one, once you have submitted a complaint to the CCMA, that is where your preparation starts. Your preparation don't start a day before your hearing. No, your preparation don't start at the CCMA. A lot of issues that the commissioners have to deal with before they start is to ensure that both parties understand the processes. So, number one, from today onwards, the moment we submitted our dispute referral, whether it's online, let me just encourage you again, the CCMA have an online platform where you can digitally online submit a complaint form online without standing in queues. You just do it at the comfort of your own leisure. You go online to the CCMA, submit your complaint dispute, what your nature of complaint is. It will be electronically submitted. The CCMA will receive it. The case management officer will capture it again from that side of the table, and then they will allocate it to a commissioner. A date, a time, a venue will be allocated for your hearing to be set down. First hearing will be conciliation, or it will be a con-arb hearing depending on the nature of your complaint. But the question that Mr. Monterey Joseph is talking about is specifically dealing with arbitration. How do you prepare? How do you go about in preparing? So, step one, let's start with it today. Step one is that from the moment you submit that dispute referral, we are going to take this journey together. We are going to gather all our facts. We are going to start going on, whether we go on Google search, go on the CCMA website. We are going to familiarize ourselves, number one, with the environment of the CCMA. That's the first thing. If you are out of town, for instance, out in Ceres, Woolsley, Vredendal, Saldanha, and the CCMA has to come out there. The CCMA make use of the Department of Employment and Labour offices, the satellite offices in the remote areas, to literally have these hearings. But if not, then all the hearings are held in Cape Town at the 78 Darling Street in Cape Town. So that's where all the hearings are held. So number one, familiarize ourselves with the environment of the CCMA. I lodged my complaint. Who are the people that is part of my complaint? I don't need to know everything, because the moment I get my SMS, I don't need to know who was the case management officer. The only once you get your SMS with your case number, and if your case was lodged in Cape Town, Western Cape will have WECT as a prefix to your case number. And depending on the year that you lodged your complaint, it will have a suffix of the year that you submitted, -23, -2022. Next year it will be -2024, 24, just 24 and 23. So you'll get a case number. You will also get a date of your hearing, a SMS. You will also get a time when your hearing will be held. Please, let me say this. Number one is that from that moment we've submitted our complaint, we are going to gather information, not just about the process. So I'm going in. What is the processes? One process that the CCMA have is conciliation only. Conciliation is off the record, without prejudice. Without prejudice literally means that whatever is being said in that process, in that hearing room, you cannot now go outside and repeat what the other party have said, because it's without prejudice. You cannot go and repeat in an arbitration hearing, for instance, and say, but during conciliation, this and this was said. You cannot repeat. It's off the record. It's a very informal process. It's the purpose of it is to see whether the two parties can resolve their matter. So you have a story. You don't have to make it long in conciliation. Give us the crux. What is it? You were either dismissed or they treated you unfairly. And what is it that you want? So we're going to gather information of how do I present myself? What do I present? What do I take with me? What evidence do I take with me? And it's important. Just yesterday, one of my colleagues, listen to this very careful, had to postpone a case for a claim for outstanding money. Guess what? The reason? Because the parties were not prepared with all their documentations coming to the hearings at the CCMA. The last thing you want is that you want a postponement, especially if it is for outstanding money. So be prepared. Gather all your documents. Put them in a chronological order. Put page numbers on your document. We're going to take it step by step. We're going to take it slow. I'm not going to rush this thing with giving the information, but it will assist you. If you have received an arbitration date for the CCMA to appear and you don't know how to handle it, let me encourage you, stay tuned to this program, because we are going to continue, not just today, it will probably be next week as well. And I think the week after that, we will talk about the rules of evidence even. What kind of evidence? What evidence do you submit as part of your bundle? Even if the employer brings evidence, what evidence can you object to when the other party brings those evidence? But before I continue, let's take a music break there.
Yes,
Our station, our talent, our people.
Tidang Ragi.
Faithful friend and father, I called you through the years. You've been great physician when sickness lingered near. Through distressing moments, is new and sweet. You've become comforter to me. You are comforter. That's who you are to me. Comforter, a name that fits so perfectly. Peace that passes all understanding. Comforter is who you are to me. It's who you are to me. And to the grieving family who weep for loved ones gone, the pain of separation consumes another home. But on the waves of sorrow, you walk with perfect peace. Comforter is who the whole world needs. You are that comforter. That's who you are to me. Comforter, a name that fits so perfectly. Peace that passes all understanding. Comforter is who you are to me. Ooh, that's who you are. Oh yeah. Joy River, Waymaker, what a wonderful changer. Please give us Joy River. That's who you are. You are me. Comforter. A name that fits perfectly. Peace that passes all understanding. Comforter is who you are me. Comforter is who you are to me. Oh, life changer, peace giver, flowing and flowing, flowing and flowing, joy like a river, joy like a river, yeah. Peace giver, waymaker, life changer. He can make a way out of no way. Peace giver, comforter, what a faithful friend. My Father.
Yes, Rafi.
Our station, our talent, our people.
Tidang Raki.
Thank you very much to all of you. Thank you for the contributions that all of you have made, Mr. Monre. Joseph, thank you very much for the question that you've posed, because that question is now leading into a discussion which we will unpack next week. I did not realize how quickly the time has passed. Ms. Jenny Aris, thank you very much for tuning in this week with us. I trust that you will share this link to as many as you can on your social platforms as well. As this week we have just discussed Rule 25 in terms of representation at the CCMA, and but it's now linking into proceedings of arbitration. So what we will do next week is we're going to unpack, and we're going to give you some tools to use, which is amazing. You may not be, so grab a pen, grab a book, record this link as well, or the session as far as you can. You want to replay it over. If you have any queries, any questions, pop it to us in the meantime, that we can maybe engage with you on that. But we're going to give you some tools how to prepare for the arbitration hearings. When you do go to an arbitration, what do you take with you? How to present your matter at the CCMA? What is the things that the commissioners will look at? Because when they analyze the facts in terms of the evidences that is being presented, what does the commissioners look at? Look, I'm not going to say that after these sessions you will win your case. I'm going to say that after these sessions you'll feel more boldness and assertiveness to engage with the commissioner when you do come in an arbitration hearing, that you'll feel a little bit, and I pray that you will feel more confident in yourself to present your matter. Or if you cannot present your matter, then you will assist somebody then that will present your matter then for you with the information that we will provide. So thank you very much for tuning in with us this week to Radio Eerste River. Mr. J.O., who has entertained you with some music, on behalf of him, thank you very much for sharing the link. And then we will see you next week, same time, same place, with me, Labour Talks with Commissioner Samuels from the CCMA on a Wednesday afternoon. Thank you, and have a wonderful week ahead.
Our station, our talent.